Hello, everybody, and welcome to our last Zoom meeting for the first Thursday. Just a reminder that next month we'll be meeting in person. Also, we have a lot of activities happening this weekend. So starting with the Bend Holiday Parade at noon on Saturday, we have 20 walkers that are going to be joining us, maybe a few more, maybe a few less, but it's going to be lots of fun. And at 2 o'clock, we have our holiday party from 2 to 4. So looking forward to seeing all of you in person. Yesterday, we also received the president's newsletter from the State League president. And in there is the Oregon Third Annual Prescription Drug Price Survey. So if you want to look at your newsletter, you can click on there and complete a survey about drug prices. And then there's going to be a public hearing on Wednesday from 1 to 3. Also, we're going to be looking for somebody to help us with the Vote 411 because we're going to have a busy year next year with all of the races that are happening, including the governor's race, which is already hot and furious. So it's going to be really fun to watch. Anyway, that is about all I have. Mimi, I think you wanted to mention something.
I'm trying to think. Oh, well, there's going to be a presentation. We were invited as the league to present to OLLI, which is the University of Oregon's Lifelong Learning Institute. And we're going to be doing that presentation on December 9th, and everyone's invited. So I did send out an email today with a link to that Zoom meeting if anybody wants to come and watch us do it, where it's Carol and Joyce and I, and we're talking about our national and state history, and also actions that we're doing on a state and national level, in addition to local activities. So you're welcome to come to that. And if anybody hasn't yet had a chance to sign the petition to make our county commissioners nonpartisan, please let me know. I will drive to you and watch you sign it. Thank you.
Okay, Karen, it's back to you.
Okay, I would like to wait just a few more minutes so people don't log in the middle of Bobbin's presentation. I see that Bobbin is here, so welcome, Bobbin. And a lot of people log in right at noon, so I would like people to get to hear the full presentation.
Perfect.
So if you delay for a few minutes, that would be great.
Mimi, could you talk a little more about the petition? I would like to sign it, and I don't expect you to drive all the way to my place.
Oh, I will do that. We're a little over halfway with the signatures for getting on the ballot the initiative that would make our county commissioner position a nonpartisan position. And so if anybody, I know we haven't had a lot of chance, I will bring a petition to the party. And so I'll have a place for people to sign there if you haven't had a chance yet. It's been so hard because we can't be together. So, you know, gathering people up to sign a petition just doesn't work as well. But we're still about halfway there.
Great. And when would that be on the ballot?
If we can get enough signatures, the other half before about the early February will be on the May ballot. If we can't, we're going to keep pushing forward. And as long as we can get it, what our initiative says is that we want it on the ballot in 2022. We didn't nail down which election in 2022. That way we left ourselves open. So then we have until the following August to get all the petitions for the November election. So I think we'll be able to do it. It's just a hard slog.
I see we have one new member. Welcome, Mike. You're on mute, but that's okay.
Thank you very much. I'm glad to be here.
Yeah. So.
And it's good to see Karen's smiling face. We so seldom get to see each other smile.
And I've made Bobbin co-host, so if he has any slides that he wants to share, he's able to do that without any glitches. Okay, 12 o'clock has rolled around, and in the interest of respecting Bobbin's time, I will go ahead and get started. Today, our speaker is Bobbin Singh, who is the Executive Director and founder of the Oregon Justice Resource Center. Bobbin was born and raised in Atlanta, but moved to Oregon in 2003 for his undergraduate degree in law school. In 2011, shortly after finishing law school, he founded the Oregon Justice Resource Center. Bobbin believes that mass incarceration is the civil rights issue of our time. He argues that for individual rights to have any meaning, we need to respect rights for all. If you have ever heard of the Trailblazing Justice podcast, Bobbin started that podcast with a public defender a little over a year ago and had 18 episodes. If you listen to that podcast, you actually learned a whole lot about how the judicial system in Oregon works. And you also would have learned that Bobbin is an avid Trailblazers fan. Please welcome Bobbin Singh.
Well, thanks for having me. And yeah, it's the podcast, we actually had to suspend just for a little bit of time because my counterpart, Eric and I got really busy with the legislative session and things that happened afterwards. And there's some transitions happening with his agency, but we're hoping to actually get that started back up this month. So we're pretty excited. It's a fun podcast to do, but we have a broader concept of it to engage more people and have it hopefully something that it can be used as a public education tool. But thank you for having me. I really appreciate the opportunity to be able to talk today about the Oregon Justice Resource Center. The one advantage of us transitioning remotely is that we've been able to talk to far more groups and audiences, not only in this state, but across the country because travel isn't required anymore. So it's just one of those things that we find like very enjoyable at this moment and hope that, this aspect of our engagement will be able to continue in what we hope will be a post-COVID world at some point. But, this is a fun thing for us to be able to do. So I really appreciate it. And, as an Oregon-based organization and a statewide organization, obviously, outside of the I-5 corridor, Deschutes County is one of the places in which we end up doing a lot of work. And so it's nice to be able to talk with you in Deschutes County about the OJRC. So I was sent some questions just to kind of prompt my conversation today, but I'm also, if you have any questions along the way, I'm much more prefer like a dialogue or a conversation. So please feel free just to jump in and ask, and I'm happy to, entertain those along the way rather than trying to wait till the end or anything like that. But, I'll start just with the arc of the questions, which just talks about, asked me to talk about the origins of OJRC and the scope of work that we do, and, everything in between. And so that's always easy for me to talk about, and we do a lot of work. And again, if you have a particular question about any one of our programs or anything like that, just please ask. As was mentioned, I was, I co-founded this organization in 2011 after I graduated law school. And when I went to law school, I went as a non-traditional student. So I was born and raised in Atlanta. My parents immigrated to the United States in the late 60s from India, and I was born and raised in a Sikh family. And part of the Sikh tradition, at least those who are more, Orthodox, is that you don't cut your hair. So my father had a beard and a turban, and I grew up wearing a turban until the age of 16. And growing up in Atlanta, I was born in '78. And growing up like in the 80s and 90s in Atlanta, before Atlanta was kind of an international city that it is now, or a bigger city, it was a very much another Southern city. And I think, we quite frequently experience bigotry, prejudice, discrimination. And it was something that was just kind of normal. Like I didn't know things could actually be different or should be different, when I was young, because that's just kind of the society you grow up in. I knew it was wrong. And from a very early age, I did try to understand it and try to make sense of like, how do you deal with this type of experience or these types of experiences? And the benefit of growing up in Atlanta is that you're just saturated in the history of the civil rights. So I will joke, like the first names that you learn growing up in Atlanta are often like MLK, Andrew Young, John Lewis. I grew up in John Lewis's district, or what was John Lewis's district. And so, I was just very fortunate to be able to be sort of saturated with that history and be exposed to that history from a very early age, and would look to that as sort of guidance as to how did people just deal with discrimination? Like, what is this? How does this exist? And while that experience and that history was very different from my own personal experience, it's that experience of being othered or marginalized or not welcome that was common, that I could relate to. And I think that stuck with me from a very early age. And I didn't really know how that would develop professionally, because I had sort of a very winding path to law school that included an unsuccessful attempt at university education or higher education in Atlanta. I started at Emory University, but didn't do well. I had personal issues going on and ended up dropping out. And then I moved to the West Coast in 2001, in the summer of 2001, and lived in the Bay Area for a couple of years, where I managed a snowboard and camping shop. And then I moved up here in Portland in 2003, in large part because I had come up to Portland and learned about Portland State University. And at that point in my life, I really knew that I had to get back into education, but needed a smaller city to live in, someplace where I felt like I could be more focused. So I moved up to Portland and got my residency, worked odd jobs, and enrolled in Portland State. And Portland State was attractive to me because it was a non-traditional university. It was, it's focused on older students, and it felt very welcoming for me to be able to come back into education and not feel like I was, a fish out of water, out of place, or anything like that. And a lot of that had to do with just, my own pride and ego, like not wanting to stand out or, feel embarrassed about who I was or my experiences. And, one quarter after another, I was just able to generate success, and it felt good, build up my confidence. And my focus was on history and political science, specifically of Middle East. And there's not much you can do with that. So I started looking at like PhD programs and law schools, and didn't really have a full understanding of the legal profession or what attorneys do. The only thing I really knew as I understood the legal profession was the ACLU, the Legal Defense Fund, and civil rights work. Because growing up in Atlanta, that's what I understood attorneys to be. And I didn't understand that was only like, a couple percent of what the legal profession actually does or what attorneys do. And so when I got accepted to Lewis and Clark, I decided just to stay in Portland since I was here and not go to any of the other law schools that I applied to, and attended the evening program. And while I was at Lewis and Clark, my first instinct was, I think what a lot of law students do there is think about environmental law. And so I explored that. And what I realized very quickly is, man, the passion that people had for environmental law, like I could not even fake it. Like it was something that was the people that were were experiencing a lot of success in the program, both within academia, but sort of external to that, like with internships and externships. Like they just had a passion and a drive that I just didn't have. And so it made me really think about like, what are the things that I was passionate about? And it was really around civil rights and civil liberties. And for me, anti-death penalty work was something that I've always been, has always been something important in my mind. And so I got hooked up with a capital defense attorney, Jeff Ellis, and started working with him while I was in law school. I actually worked with him on the last case, the last individual that was executed in Washington in 2010, I believe it was. And then I started working with the ACLU Oregon as a volunteer. And that's where things just kind of clicked for me. And while I was in law school at that time, there was actually no opportunities for law students to work on criminal justice or civil rights issues related to the criminal justice system. So me, my colleague, Erin McKee, I was working with Metropolitan Public Defenders at the time, Jeff Ellis, and she was working with the Immigrant Rights Organization. We went to these entities or attorneys and said, what if we recruited additional law students? And we co-managed those law students to make sure that they did their work, but we were able to help do some projects that would benefit your clients and the work that you're doing, and they agreed to it. So while we're in law school, we actually developed this like quasi-clinic or research group for law students to be able to work on these issues. When we graduated in 2011, the job market wasn't very strong, and there weren't very many opportunities for us to work in these areas. And we were both older at this point, both Erin and myself, and knew that this is what we wanted to work on. And so we decided to take that concept of a legal entity that focused on these issues, this civil rights issues related to criminal justice issue, the system, and we incorporated a nonprofit. And that was how OJRC was created, was based off of that work that we did in law school. We incorporated as a nonprofit with no funding. I worked out of my apartment for the first year with no funding, and I just said, I'll give it a year, I'll live off my savings that I had, and if I can get a grant or something like that after the first year, then we'll continue it. And it was actually, I met my wife at law school, and she's from Hawaii. She came from Hawaii to law school, and we agreed that she was a year or so behind me, that we would wait a year until she graduated, and if we didn't have anything here, we'd move to Hawaii. And so as we were filling out the applications for the bar exam in Hawaii, we actually received our first grant for the OJRC. So from there, I've just focused my energies on OJRC, and we've been able to secure funding and grow over the past 10 years into a public interest law firm that now we have 45 employees and 6 legal programs, 7 really legal programs that provide legal support and services to individuals that are going through the criminal system or who have been impacted by the criminal system. And we provide services and supports to between 700 and 1,000 individuals that wouldn't otherwise get access to legal supports and services, but for our organization. And along the way, we've had like a lot of fun doing things, and things have spun out from our organization. That clinic concept that we created actually is what developed now what is the Lewis and Clark Criminal Justice Reform Clinic. We helped co-create that. So it's that idea of like having students be able to work on this. We were able to help make something permanent in Oregon for our students to be able to work on these type of stuff. And now we're the only legal organization that is involved from the point of arrest all the way through reentry in some capacity. And so the model that we have for OJRC, we call it client-centered integrative advocacy. And what that means is, first and foremost, our clients are the priority, like through our legal support services and programs. We advocate on behalf of their interests first and foremost. But we use what Brian Stevenson talks about, that proximity of being with our clients and understanding their experiences to inform our systemic or policy reform ideas. So it's really trying to understand with nuance how the laws are impacting our clients, what's going on, and then using that experience and knowledge then to inform the policy reforms that we engage in. And we've had some success with policy reforms that are hyper technical and seem very small, and we can't even do public education about it because we can't explain it. Like it has to do with like a particular program in a prison that impacts like 200 or 300 people, but we were able to change it so DOC cannot suspend this program ever again, because if you participate in this program, you get an early release date. And during COVID, they suspended this, and all the release dates for individuals were changed, and that really impacted people. But it's like it's really hard to explain why that's important in like a short, sort of paragraph necessarily in broader public education. But maybe it's not. I don't know. But the idea is that we really try to use, that knowledge to think about reforms that can really impact people in meaningful ways or help protect people in meaningful ways. And so when we think about integrative advocacy, what we also think about is opportunities for litigation or impact litigation. So we try to identify in ways we can use the courts to get a greater policy reform. So some ruling from the court that while it would apply to the individual client that is involved in the case, would have broader application to all the cases that come afterwards or the issue more broadly. We do policy reform, public education, and communications. So we look at all those tools as ways to try to develop and move issues. And then we look at every branch of government. So we're involved in the courts, at the trial court, the Court of Appeals, the Oregon State Supreme Court, the federal courts. We look at the legislature. So we're primarily engaged with the Oregon State Legislature on policy reform areas. We work with the executive. So we do a lot of work in advocacy alongside or against the executive agencies that exist and with the governor's office. We have worked with the governor's office closely on clemency over the past number of years, including helping to support sustaining the moratorium on executions that Governor Kitzhaber started, that Governor Brown maintained, and the most recently clemency efforts for all those individuals or most of those individuals that got left behind by 1008. We engage in the administrative rules process. So we are looking at agencies as they create new rules, like in the prisons or the Board of Parole, and comment on the rules and have go to participate in the hearings on the rules. And then we also engage at municipal and county level policy conversations. So we're looking at not only all the different tools of communicating, educating, advocating, but we're also engaged trying to think about how to use every branch of government to move issues. And sometimes what we try to do is use one branch of government to create pressure on another branch of government, either through the courts, through a ruling, or to get the legislature to do something, or to get the executive to do something. So that's sort of like the model in which we use. As far as like the scope of work, the legal programs that we have are, our sort of most well-known program is the Oregon Innocence Project. So that's a program under the OJRC. The Innocence Project, as you may know, represents individuals that are currently incarcerated that are claiming factual innocence. We launched the Oregon Innocence Project in 2014. Oregon was one of the last states to have an innocence program. Since 2014, we've been successful with 3 exonerations, including one out of Deschutes County. That was not 2 years ago. And we worked alongside DA John Hummel on that exoneration. That was a joint investigation that we did with him, which is unique. It's not something that's very common to be able to work alongside a DA in trying to understand whether or not someone was wrongfully convicted. And most recently, we had an individual who was on death row, and we're co-counsel in that case, but his case was reversed and is now back at the trial level for the Marion County DA to make a decision on how she wants to pursue that case. But we believe in his innocence, and hopefully he'll be exonerated soon as well. We have our Women's Justice Project, and I think you've hosted Julia Yoshimoto before, but she's the director of our Women's Justice Project. And this program provides non-criminal or civil legal support to women that are currently incarcerated in Oregon's women's prison. And again, it's much more than that, because from the experience of working with women, we get to understand what's going on and how they're going through the system. And then we look for other ways of advocacy for the women that are currently incarcerated. We have our Civil Rights Project. This is one of our affirmative legal programs. Every other legal program we have is if you fit the criteria for legal services, we will provide those legal services to you. Like if you're a woman incarcerated in the prison and you request services, you'll be put on the wait list and you'll meet with an attorney and they'll review whatever issues and provide those services. Same with the Oregon Innocence Project. If you fill out a questionnaire, you meet the criteria of what looks like an innocence client, we'll begin an investigation and begin to review that case. With the Civil Rights Project, what we do is we're not selective in the cases in that we're just looking for impact cases, but it is the cases in which we're looking at either when people have been harmed by police or state actors, conditions of confinement issues. And then most recently, we have actually 3 active lawsuits against alt-right groups or individuals associated with alt-right groups. So we're looking for areas in which we can protect our community members from harms by either the state or lack of action by the state. But that's the one in which we just don't take every case because we can't. We actually have so many people calling us for assistance that we're just not able to help everyone with the civil rights issues. And the way the courts work on civil rights cases is that it is quite difficult to be able to be successful in court. And the court and civil rights way is more of a backstop. So it's like almost like the last thing. The courts aren't going to get to any speedy remedy. So oftentimes, like if we do hear about issues, a lot of our advocacy for those individuals will actually happen outside of courtrooms. Like if there's medical issues that we're seeing for people in custody, we actually just try to reach out to like DOC or people within DOC to try to advocate for them to get access to healthcare immediately, because it doesn't help to wait like a year if you have, a broken arm or something like that needs attention. But our civil rights project is currently involved in a class action against the Portland Police Bureau for its indiscriminate use of chemical and other munitions during last year's protest, and also involved in a class action against the Department of Corrections for its treatment of individuals in custody during COVID last year prior to the, well, it's ongoing, but it was really focused on prior to the vaccinations. And we were able to we were successful in going to federal court and ensuring that the state of Oregon actually provided vaccinations early on to people in custody. And we have a bunch of cases in between those two that deal with police violence, including representing family members who have loved ones who have been killed by police, and then wrongful death cases out of the prisons as well, and jails. Our Immigrant Rights Project is another legal program that we have. We have a contract with the state of Oregon that under the Constitution, defense attorneys are required to inform their clients if they're non-citizens. So if they're here with status and if they're arrested or charged with crimes, that will impact their immigration status. And under the Sixth Amendment, defense attorneys are required to inform those clients of the immigration consequences of the arrest and conviction. Oregon interprets that mandate as actually having immigration attorneys available to defenders or public defenders across the state. So we have 2 immigration attorneys that are available to all public defenders at no cost that will do consultations on the assessment or the impact of an arrest and a conviction would have on an immigration status. And the idea is really try to work with people to see if we can negotiate a plea to give people the best opportunity not to be deported. I will say the vast majority of cases that come through our office, which is anywhere between 600 to 700 consultations alone with just the Immigrant Rights Project, are people who have been here for quite some time and have just done something stupid. And I say stupid in the sense of like, it's a mistake. It's not career criminals or, people who are engaged in criminal activity in any big ways, but I think, it's a DUI, it's a bar fight, it's, neighborly disputes, things like that, that I think you would begin to look at and say, like, any one of us could actually accidentally slip into one of these things for bad facts or situations or something like that. And so the idea is really try to, and these are people that typically have like families that have been here and are established. So the idea is not only to work with defense attorneys, but our immigration attorneys also work with prosecutor's office to help develop policies to ensure that the immigration status doesn't bias the prosecution, and that they're focused on what the underlying harm is, and that's it, and not allowing other sort of biases or prejudices to interfere with that public safety sort of assessment. We have our Youth Justice Project. So this is a program that focuses on the adult treatment of youth in our criminal system. So prior to 2020, as you may know, under Measure 11, if a youth was charged with a certain crime, they would be automatically placed into the adult court system. After 2019, Senate Bill 1008 changed that. So now youth have to start out in the juvenile jurisdiction and have to go through a waiver process before they're put into the adult system. Our program was really developed out of that what was happening in the state of Oregon, and really focusing on not only individuals that are currently being charged with those types of crimes that could now land them into the adult court system, but those individuals that had gotten left behind by 1008, because that was a perspective only bill, but really trying to think about how do we create a holistic support system from arrest through reentry for that population of individuals that are going through the system. And that has led to not only legal support, but the development of an innovative peer support program where adults in custody and prisons have created peer mentorship programs, or we're in the process of it. It got delayed because of COVID, whereas youth or individuals were being transitioned out of the youth system into the adult prison system, that they could go into prisons and have mentorships there that would reach in prior to that transition. So they would have a community to come into, be supportive, understand how to navigate the prison system, and understand how to navigate in pro-social programming, get access to those things, and then replicating that as people were re-entering the community so they would have the best opportunity to be successful when they came out in the community. Understanding that growing up in prison is a unique experience, and there's a lot of what we call habilitation that has to happen along the way, and we want to make sure that individuals are supported along the way, or at least have the opportunity to be supported. We recognize that some people may not be ready for that engagement, but when they are, that there's a community of people that are there to support them along the way. So we have a really great team that does that.
Bobbin, while you're talking about the Youth Justice Project, there's a question in chat. How do you feel about the 15-year-old shooter in Michigan being treated as an adult?
Yeah, I mean, it's a good question. I think, too often the question is set up or understood in a binary as that, if we treat someone, a youth, as a youth, that they're not going to be held accountable, and that systems, including ours, are set up in such a way that if that individual were in Oregon and were remaining in the juvenile system, they would lose jurisdiction at the age of 25. That's just the law, and that we would not be able to hold that person in custody past the age of 25. So the only way to be able to hold someone after the age of 25 would be to prosecute them as an adult so they could have those longer sentences and be in an adult prison. So I would say, first and foremost, in that context, I don't think any youth should be prosecuted or treated as an adult, because it's a fiction. It's a fiction that we've created that doesn't mean anything. And we know from brain science and all the social science research that youth are just not adults. Like, they don't have the intellectual or cognitive abilities that are even comparable to adults. So then the second question becomes more, I think, how do we hold that individual accountable in ways that ensures public safety and ensures that that person's held in custody for a proper amount of time. So if that person were to come back into the community, that they're coming back in a way that's safe. And I think that's the question that we really need to hone in on, is how do we create sort of a middle ground between being prosecuted as a juvenile, but being able to serve a lengthier sentence, but not being treated as an adult, and understanding that there may be different systems that need to be put into place to ensure that. And so that's, the direct answer to that question is I don't think youth should ever be treated as adult or prosecuted as adult. It doesn't make any sense. But I do think we need to have a deeper conversation about how to hold individuals in custody or accountable, and giving opportunities, meaningful opportunities for release. So let the individual have an opportunity to prove rehabilitation and prove the opportunity to come back into the community at some point, and have those be meaningful. I hope that makes sense.
It does.
Right. Let's see. The last program I think we have is our legal support services program. I feel like I'm missing one, but I'll go back and look. But our legal support services program is, we recently merged with a for-profit entity that was called Criminal Defense Support Services, but we brought it underneath ours as legal support services. And this is a team of investigators and document management specialists. So Oregon's public defense system is a quirky public defense system in the sense that in the higher population areas, we tend to have what are nonprofit agencies or organizations in which public defenders are based out of and represent people charged with crimes. In smaller populous areas or lesser populous areas, we have consortia. So like individual attorneys that have come together to form a consortium that have agreed to do public defense representation, but they're not managed by some nonprofit entity. Part of that means that they don't have like administrative staff or investigators or document management individuals that can help them with case preparation. So our public defense system allows for those defense attorneys to contract with staff, and they can get reimbursed through the agencies for that time. So for that work. So we have a team of document management individuals and investigators that actually work with public defenders across the state on investigation and document management, and we get reimbursed through the state for every hour worked. And so that gives us another opportunity to get a better sense of what's going on in the state as far as on criminal defense trials. One of the unique aspects about the Legal Support Services program too is on the document management side, most of the team is formerly incarcerated individuals. So we're a second chance employer, and a lot of them are actually formerly incarcerated youth that were like youth lifers or individuals that served, 15, 20 years in prison for very serious crimes, but are back in the community and doing very well. And so we've actually had a number of those individuals kind of promote out of that document management into sort of general paralegal or legal assistant positions into the organization as well. So it's something that we're very proud of, to be able to have that opportunity and to be able to be an employer that way in the organization. So I think there's a question about how our programs are funded. It's a very good question. So what I'll say is, for the first part of the year, first part of OJRC, the first 5 years, we were really supported by foundation grants and individual philanthropy or donors. Since then, we've been able to diversify our funding. So we have a state contract for our Immigrant Rights Project, for the Women's Justice Project and the Legal Services Program at Coffee Creek. We were able to get money through the legislature. So we actually got a bill passed that helped create the Legal Services Program at Coffee Creek. So for the past biennium and even this biennium, legislative funding is supporting that. We continue to get grant funding, primarily local funding. We've had corporate funding. So the NFL has been funded us just recently. And then we've been fortunate to have some very generous individual philanthropy come in to support the Youth Justice Project. And the last program that we just launched, which is why I knew we had one more, is the Fair Law Project. So we had an individual donor come in and actually talk to us about like what our needs were and what we were seeing as the next sort of thing that we really wanted. And one of the things that we see with all our programs is what we call wrongful convictions, sort of more broadly. So this idea that you may not be innocent, but we also see like excessive punishment or sentences that are disconnected from social science, or practices that are, junk, like forensics that are, faulty forensics that are used, or just false, bad investigative practices or misconduct issues. So this funder generously has given us multi-year funding to scale up a program that would focus on these issues. And so what that looks like in reality is, in Central Oregon, we learned of a defense attorney that wasn't actually reviewing evidence before settling pleas for clients. And so the Office of Public Defense Services, which oversees public defense here in Oregon, saw this and recognized it as a problem. It was actually the DAs that brought it to their attention as a problem, and asked us to review like 400 or 500 cases that he recently was involved in. So that's what we're doing, to see if we're going through what we call mass case reviews to see whether or not those cases should be reopened and re-examined. In another jurisdiction out in Wasco County, we were actually invited by the DA to come in because he had learned of a law enforcement officer there that had lied on some things previously, but the previous district attorney never disclosed that to the defense attorneys out there. So the current district attorney asked us to come in and review 750 cases that this law enforcement officer was an investigator in, to see if any of those cases should be re-examined. So that's what we're doing there. So, the big things that we're doing with this program right now is looking at those misconduct issues where they're identified and reviewing these like mass cases, but we're also looking at excessive sentencing issues, or we see bad sentencing practice, and looking at them more as class of cases as opposed to like individual cases. So everybody that's impacted by this one kind of charging practice that we've identified in a county, which is potentially hundreds of cases. Like we want to look at every one of those cases and see how individuals were charged and how the charging practice may have been abusive in creating higher sentences than were actually necessary. This program in its first year will be primarily like a local facing work. In its second year, the idea is it to actually be a national facing resource for other states. So we can kind of teach them how to do these types of mass case reviews and how to create a plan to be able to think about these, because oftentimes these issues will come up, but there's no capacity or resources or experiences to be able to do the reviews or understand even how to begin those reviews. And other people are likely impacted by, you know, some of this misconduct or bad practices that we're seeing.
And we have
So
a couple of questions that kind of or focus on policy. One is, what are your top 2 to 3 priorities for policy reform? And then they also ask if you are actively working to end the death penalty in Oregon.
yeah, with the death penalty, always. That's been a core issue of ours since the beginning. That, you know, like I said, when I was in law school, anti-death penalty work was something that was central to my experience at law school and was very central to our experience, to OGRC's work from the very beginning. And I'll talk a little bit more about what that looks like. As far as like the 2 or 3 priorities for policy reform, what I can tell you is the 5 priorities for the next 6 to 8 months and what we're focused on. There are 3 policy concepts that are going to be introduced in this upcoming legislative session that we're really proud of. We introduced them actually in 2021, but it didn't pass. And so we were able to generate additional sort of support and work on them in the interim. They'll be introduced in 2022. One of them is the restoration of voting rights for individuals that are currently in custody. It's not official yet. We hope to make an official announcement about it, I think, next week. But it looks like Rep. Reynolds will be helping to lead that. That will be a priority bill for her, and she'll be helping to lead that. Another one is a compassionate release bill. This is something that we're working on with Rep. Reynolds and Senator Dembro as well. This bill would create an independent medical review committee that would consist of 7 to 13 medical professionals that would review requests for a broader criteria for compassionate release, an expanded sort of concept of compassionate release. And they would make an independent assessment based on a medical or public health analysis or review of whether or not an individual should receive compassionate release. Once they make a review and a recommendation, that would go then to the Board of Parole or to the sentencing court with a presumption of release unless that could be overcome for a public safety issue or concern. This would be the first of its kind in the country to create an independent medical review board to actually do compassionate release, which seems very sort of sensical when you think about it. But most compassionate release has happened, you know, through the Board of Paroles or other mechanisms with people who don't actually have medical backgrounds. So this is something that we're all excited about. In its initial sort of iteration, in the first 2 years, it will be limited in how many people could petition the medical review committee. We spoke with CJC, even with the limitations on who and how many could petition, there would still be a lot of people that would be eligible for it. And then in 2025, the idea is all those limitations or restrictions would then be lifted automatically. So the idea is to try to get this infrastructure in place, work out the mechanics of it over the next 2 years, you know, put the board in place. They will have to promulgate rules. And then in 2025, the hope is really to have it really moving in full capacity and allowing anyone, no matter if crime conviction or what, to be able to apply for compassionate release without any numerical sort of cap on how many people could petition. The third bill that we're looking at is compensation for wrongfully convicted individuals. So we're one of the few states that actually doesn't have compensation if you're exonerated here in Oregon. And this is a bipartisan bill. And we feel very confident that this one will move forward and will pass in 2022 as well. and there's a number of legislators that are leading this up, and I'll have to go back and check to see who they are, but Senator Thatcher was actually the lead on it in 2021, and she and other, I mean, it's a large number of Democrats and Republicans that are supporting this bill now in 2022. The other policy areas that we'll be focusing in on are going to be dealing with solitary confinement. So that's something that we'll be making an announcement about pretty soon here. And then in 2021, we introduced a bill around the issue of survivor defendants, which is individuals who have committed crimes out of their domestic violence experience. So this could be a crime against the abusive partner or family member, or someone that was coerced into committing a crime against a third party, whether it's a property or person crime. Our current laws don't allow for that situation to be considered either in the guilt, sort of the guilt kind of understanding and sentencing aspects of it as well. So our bill would allow a judge to depart out of mandatory minimum sentences and apply a sentence that was appropriate for the circumstances, and allow people currently in custody to be able to petition the court after a period of incarceration to have their cases or sentences re-examined based on evidence they weren't able to introduce at sentencing. Understanding that the psychosocial dynamics around domestic violence is, a lot of the women we work with, unfortunately, have grown up in very traumatic and violent homes. And it's not until they're incarcerated and several years into their incarceration that they even recognize that they were in a domestic violence relationship, or, because that was just the norm for them. And, that just a reality that we have to face and figure out how to provide remedies. So those are the big policy areas that we'll be working on over the next 6 to 8 months.
There's another question here about policy. Are you at all involved in developing policy for the felony expungement program, Senate Bill 819? And there was just an article today in the Ben Bulletin about that program on the front page.
Yeah, so 819 is an interesting, bill that was passed in 2021 that allows, a motion by the defense attorney and the DA. It has to be a joint motion to come back and have someone's underlying conviction and sentence changed. We supported its passage. It's highly dependent on the DA. So we know John in Deschutes County is very open to these 819 motions, and he doesn't have like a very narrow criteria in which he's looking at. Like, I think he's just looking at what we would call like manifest injustice. If you have a case, if we have a case that presents like something that needs additional examination, or we think that deserves the person to be released, John's open to like having conversations about those. There's most of the DAs in the state aren't even interested in it, to be honest. So unless they're interested in sort of engaging in this conversation about excessive sentencing or manifest injustice, or something that could be corrected under 819, like there's no opportunity. In Multnomah County, Mike is developing, I think, policies around it. We will be putting out a resource of what we think are best practices around 819 in an attempt to help show how DAs can use it and how it should be used. Encouraging the DAs that want to use it to use it perhaps more broadly, more expansively, and to encourage the DAs that aren't interested to adopt, the best practices or standards or criteria that we will be developing. I think the next step for us, we actually had to introduce this in 2021, but we'll probably introduce it in 2023, is a parallel or a companion bill to this, which allows for this same thing to happen, but for you to go to the judge without the DA's permission. Like, because at the end of the day, for our organization, when we look at reform, the true metric of what we look at a reform is there a reallocation of power away from the district attorneys and back to the judges and back to defense attorneys? That is really the true metric of reform. Like when we're talking about attacking the asymmetrical power dynamics that exist or within an agency like the Department of Corrections or whatever. So when we look at 819, what we see with a lot of reform is just additional discretion with the district attorney or with the system stakeholder, but not actually a reallocation of power or giving people the ability to make more decisions about how to navigate the system or opportunities to earn release. And so 819 I think was a good concept, but the fact that it continues to remain dependent on DAs is highly problematic from my perspective. And so we're going to continue to look at other policy options that allow us to be able to move these cases without the DA's permission. So to answer your question, yeah, we will put out best practices and we'll develop like what we believe is a sort of model policy that DAs could adopt when they're considering 819. But it will just largely be DA dependent, jurisdiction by jurisdiction, as to how effective or even if this is used at all. But we do have a lot of high hopes and optimism, at least to be working with John in Deschutes County.
I have another question about policy. Recently in the paper, there was discussion about how Philadelphia is really dialing back on their routine traffic stops. And we recently read in our book group, Tangled Up in Blue by Rosa Brooks, who talks about how often those go bad. And one thing that really impressed me about that book was that just in DC, there are 13 pages of possible traffic violations that people can be stopped for. So I was wondering about your thoughts about that, because those can go really bad sometimes, and they can also be applied in very discriminatory ways.
Yeah, I mean, I think, my real thoughts about that is like thinking about like, why do we need armed law enforcement to actually engage in traffic violations to begin with? And, not to say that we don't need some regulations and some oversight of, how people drive and operate vehicles on our roads, but this whole idea that we have armed law enforcement engaged in this and is used very often as pretext to engage, initiate an encounter, often with people of color, is highly problematic. And so I think, we're beginning to see reforms and a broader discussion about like that first contact. I think we're starting to think about more broadly this concept of public safety, like what is the true intent of having these initial traffic stops or encounters with law enforcement? Is it really to protect like safety of the road or transportation, or is there some other sort of nefarious or ulterior motives that are attached to it? And if we just begin to focus on sort of with traffic stops, if we're just focused on safety of the road, there are, I think, so many other ways in which that can occur without creating, that level of like distrust or intimidation or even lethality that may occur with those first interactions. So, yeah, I think we have a lot of conversations that we need to have around how we reimagine some of those public safety aspects of our society. But it does start with like fundamentally questioning the role of law enforcement, especially armed law enforcement, and their purpose in our community.
So it sounds like at this point, there's no policy work being done in Oregon around routine traffic stops, but there is some rethinking happening that's preliminary.
Well, I mean, I think there's other organizations that were involved in what was House Bill 2002 that didn't pass. That included, I think, a lot of revisions to traffic stops and first encounters with police. I think some components of it may have passed. So there are policy discussions happening. We're not intimately involved with them because our focus tends to be more through a legal lens, sort of, and that keeps us busy right now. But I do think there's a lot of conversations happening. I know Chair Bynum or Rep. Bynum, this is something that she's brought up, Senator Manning as well, quite often. So I do think there was some reforms. I know like the city of Portland has, I think, adopted policies that limit these types of traffic stops now. And so it is happening across the state. I think, depending on where you live, right? Like you have different types of law enforcement that you may be engaged with, whether it's like Oregon State Police, the Sheriff's Office, or municipal police. And even that alone will sometimes dictate whether or not, this is even a priority for those jurisdictions. Like Oregon State Police, they monitor the highways and stuff like that, but they're not, I know from anecdote, like their priorities aren't like small traffic, things or anything like that. And I think in other jurisdictions, that's also the case, so.
Mhm. I know this past legislative session, you also worked on restoring rights for voting rights for adults in corrections. And we had read the book, The New Jim Crow, and learned that there are actually a couple of states where people who are incarcerated are allowed to vote. And I remember on one of the Trailblazing Justice podcasts, you did mention that you thought that it would actually be a go this past session, and it wasn't. So I'm wondering what some of the obstacles were and what you think the potential is for this legislation in the coming session.
Yeah, we had a lot of energy around that bill, a lot of support, and it only needs a simple majority. So we felt very confident that we would be able to move it. What ended up slowing it down, believe it or not, is the Department of Corrections put a fiscal on the bill. And what happens when a bill, has a fiscal, it has to go through the Ways and Means. It has, out of the policy committee through Ways and Means. And because of how this session rolled out, the politics, one of the Ways and Means members was no longer but Betsy Johnson, who's very adverse to criminal justice policy reforms. It just got hung up. That was the basic fact. Like it just could not move because it had a fiscal. And I think more importantly, no one could understand why the Department of Corrections was putting a fiscal on the bill. They said that they had to hire one or as many as two people to be able to somehow ensure that people were registered to vote or anything like that. But even the Secretary of State's office was saying, all this is through the mail. The only thing that would potentially happen, and that would be on the Secretary of State, is secure ballot boxes would be dropped off at each of the institutions, but everything else is through correspondence and mail, and that's it. So right now there's ongoing conversations with legislators, basically trying to, because we're going to reintroduce it this upcoming session, but are going to be engaging with DOC and demanding that they not put a fiscal on the bill in this upcoming session, and kind of reprimanding them, I think, for doing so, because it was the thing that really, prevented the bill from moving forward. Otherwise, we had the political support on the House side. The Senate side, I think we were really close, but we were never able to do a final kind of count because it became clear that it was never going to come to a floor vote because of the fiscal.
Mm-hmm.
But no one anticipated it. I think that was the reason. Like no one even thought that DOC would put a fiscal. Couldn't even imagine it, to be honest.
Mm-hmm. And are any other states trying this approach? And if they are they having any success?
So Illinois actually became very close to doing it this year. And I think they may be successful next year. So that's the only other state that I'm aware of that's pretty close to doing it. But what we're seeing is more and more energy around this issue. I think generally with the attack on democracy and attack on voting rights that we're seeing in so many states, there's a lot of energy and support happening in states to trying to expand voting rights where it's possible. Because, as we're learning, like it's just so precious, and some of those states are really coming down and very insidious and racist, ways of trying to prevent people from being able to vote. And I think those states like Oregon, where we have a really great, forward-thinking voting system, I think it's incumbent upon us to continue to push inclusive-ness and democracy when and where we can. Like, at this point, it feels like it's a real fight for, the value system of democracy.
Okay, we have about 7 minutes left. If there's anyone else with questions, please feel free to unmute yourself and ask Bobbin directly. Let me see if I have anything else.
Someone had asked about the death penalty.
Mm-hmm.
And so, a lot of our work around the death penalty have been focusing on sustaining the moratorium, but also we had been pushing the governor to commute death row. And then we were also very supportive and engaged with the Senate Bill 1013, the passage of Senate Bill 1013, which narrowed the crimes that are eligible to be defined as aggravated murder, which is the only conviction that exists in Oregon that makes you eligible for the death penalty. And we have been exploring like litigation ways to be able to continue to winnow down the number of people on death row and under a death sentence. And, we were able to recently be part of that process with the challenges about 1013 and its applications to individuals that are currently on death row. And so the Oregon State Supreme Court, in a decision called Bartol about a month ago, decided that essentially if you are currently under a death sentence, but wouldn't be under a death sentence under the new definition, you should no longer be under a death sentence, because death is just so disproportionate as a sentence. So essentially, the Oregon State Supreme Court has wiped out all death sentences. Like, it's still being worked out as to the impact of that decision, but effectively, we're on the path of clearing all death sentences at this point in Oregon. Now, the penalty of death still remains in effect, but for a very narrow class of crimes, or aggravated murder, but very narrow class of what constitutes aggravated murder. It's unlikely that we'll see a new death sentence anytime soon, although it could. There's always the possibility of it in these very serious and extreme offenses that may occur. But the death penalty itself is effectively non-existent in Oregon. It's a charade at most. Like it's in name only, and a complete waste of money, resources. It's a fictional sentence. My hope is in this context that we are able to, at some point in the next number of years, bring a ballot initiative to actually wipe it away from our Constitution, because that's what it would take. The problem is ballot initiatives, as you know, are so expensive. And that has always been sort of like the prohibiting factor, the major prohibiting factor as it relates to actually abolishing the death penalty in Oregon. Like, we are one of the few states that actually requires a ballot initiative to get rid of the death penalty. If we could have done it legislatively, we would have done it. I think we've done almost everything we can through legislation in the courts to effectively wipe out the death penalty, and through executive action. So I think we're in a good place. The next step is really to remove it from our Constitution, but that will take money. And the other thing with the death penalty is it's not really a criminal justice issue when it comes to the politics of it. It's a cultural issue. And so even nowadays, because of how the death penalty gets talked about, the kinds of crimes that are associated with the death penalty, which are very bad facts, egregious harms that have been endured, and that ripple through generations of communities and families, that it's a very difficult conversation to have publicly. And I think we're still not at the point, polling wise, where more people disfavor the death penalty than not. So it's and when we get into like a ballot or a public campaign, like, those conversations are very challenging to navigate, and for good reasons. I mean, they're difficult because they involve difficult situations and circumstances.
Mhm.
But I am hopeful we'll get there soon.
Okay. In the brief time that we have left, do you have any time to comment on Measure 11 offenses from that measure in 1994? I did attend one of your women's justice conferences a few years ago, and I know the whole conference focused on those mandatory minimum sentencing of Measure 11 and how it affected women in particular.
Yeah, I mean, I think very generally, when you begin to look at the policies and practices of our criminal justice system over the past several decades, and you try to connect it to either social science or human behavior or even common sense, you'll have a very difficult time. Like, they're very much disconnected from anything grounded in things that actually do positive things for human behavior or development or growth or even community well-being. And Measure 11 and mandatory minimums are a clear example of that. One of the things that we really try to advocate for is trying to have conversations about the fact that people are complex and that there are multiple truths that exist in everyone's lives, like the survivor defendant. Like you can be a survivor of domestic violence, but also a criminal defendant. You know, you can be both at the same time, which is very hard for people to understand, believe it or not. But I think with anyone who commits a crime or that is charged with a crime or convicted of a crime, the complexities exist. Like their lives are often complex, and there's no way for the system to actually take into consideration the complexity of someone's lives. And mandatory minimums are a brutal hammer to that reality. Like it's again, a fiction to somehow believe that every person is deserving of the same sentence because of the underlying crime. There are often so many different reasons why people come into the criminal justice system, why they end up engaged in the actions that they've engaged in, and why they've been convicted. And mandatory minimums don't allow for any of that to be considered. So, you know, we are very supportive of full repeal of Measure 11, but we also have to have a robust system in place that allows for proper consideration, proper resources to have like social worker, counselors, addiction treatment specialists to be engaged in these conversations on the front end and along the way. So that way we're looking at people holistically and like actually welcoming that complexity of individuals and life, you know. So you know, like, yeah, I mean, we're adamantly opposed and really working hard to find ways to move people out of Measure 11, if, you know, sector by sector, population by population, or the total repeal of it as well.
Okay. So we're at 1 o'clock now, and I want to let you go on with your busy day, but I do want to thank you for being here. I really appreciate the work that Oregon Justice Resource Center is doing. When I moved here after spending my career in Seattle 3 years ago, one of the first things I Googled was criminal justice reform in Oregon, and you guys popped up at the top of the Google search. So I appreciate what you're doing, and you have definitely shown the impact that you have throughout the state and not just in the Portland area, and the work that you do is affecting us here in Deschutes County as well. So thank you for the time that you took to spend with us and for fielding all of our questions. We really appreciate it.
Yeah, thank you so much. I really appreciate it. And if you have any questions or have any follow-up thoughts, please reach out and send an email. I'll be happy to get back to you.
Okay, thank you, Bobbin. And just so everybody knows, next month we will be in person with our first Thursday presentations. We will have 2 men from the Fathers Group, Marcus LeGrand and David Merritt. So please join us. That will be at the Unitarian Universalist Fellowship of Central Oregon at the same time on the first Thursday of the month.
Great.
Thank you, everybody. Thank you for attending. Thanks again.